and welcome to MCLE This Week. I am your host, Bruce Richard. This month, our episode is Mass Health Myths, Separating Fact from Fiction. We are lucky enough today to have Brian Barreira here to chat with us about this topic. Brian, first, do you want to tell us a little bit about yourself and your practice and what drew
Well,
you into this field?
I started out in estate planning, and then I realized that this is an issue that wasn't being covered. This, what happens to your assets if you go to a nursing home didn't seem to be covered generally in estate planning, and I started sliding into that. And before I knew it, I had published a number of national articles. And the issue of how to draft a trust and what a trust should say was particularly important at the beginning of my career, because what's good for mass health is often bad for tax and vice versa. So it's a matter of trying to um, thread the needle on planning options for people.
Right. So let's start with the basics. What's the biggest misconception attorneys and I guess the public at large has about mass health?
Well, I wouldn't know what they think, but I do know, I do know that um, people seem to think that if you're going to a nursing home on mass health, that you're going to a bad nursing home. Um, and some people don't want to do
Right.
planning. Some lawyers don't want to do that planning. But generally speaking, I know of one nursing home that doesn't accept mass health on the South Shore. Only one. There are about 420 nursing homes in the state,
Right.
last time I checked. So 90% of the people in nursing homes, from what I understand, maybe it's 80, are on mass health. So going on mass health doesn't really affect the quality of your care. The people giving the care, I don't even know who's paying and who isn't. So that's the
Is
biggest misconception, I'd say, from the public. I think from the legal community, I I think there are a lot of lawyers who do estate planning who don't realize that there are things they're doing that could be done better. That traditional
right.
estate planning can sometimes miss a lot of things that could be done for mass health purposes to protect assets.
Sure. Brian, before we started, we were sort of talking a little bit about with the estate planning versus this. I mean, what is the difference between the two? It just seems like there's significant overlap, but
Well, estate planning generally looks at what happens from the time of your death forward. Um, Elder law looks toward the end of your life about how you should be maneuvering your assets. And then deals also with what happens after you're gone. But the part before you die, there could be nothing left for you to leave behind as an inheritance if you don't make the right moves. On the
so
other hand, you can't live for mass health. You can't tie up all your assets and
right.
so that you look poor on paper, because looking poor on paper really means you are poor. Yeah.
Right.
So
So
there
what
could be too much. People can do too much Medicaid or mass health planning.
right. What are estate planners doing that or what are they not doing, I guess is probably the better question that they should be doing in relation to this.
Well, there is a cottage industry of trust mills out there. There are lawyers going around doing programs about how avoiding probate is for everybody. Everybody should do it. It's it's the only thing to do. Well, actually, for a married couple, and this is what I was talking to you slightly a little bit
Yeah.
before the we went on the air. For a married couple, actually, probate can be very beneficial. When 40 years ago, now I don't know what's in the current bill that just passed. So
Okay.
maybe this was taken away finally. But 40 years ago, Congress passed a law, and I think they made a mistake. It used to be that you could set up a trust and the trustee could use the assets for you. They were trying to take that away so that if the assets could be used for you, they would be up for grabs if you needed nursing home care. You were applying for Medicaid. Medicaid is the national term.
Right.
The mistake they seem to have made is this: they put an exception in there for a trust in a will. So if you set up a revocable trust during your lifetime, and then when you're gone, your spouse is a beneficiary of the trust. Now, the federal Medicaid trust laws say that the program can blow right through the trust and count those assets as belonging to your spouse. But if you put that same trust inside your will, if it's in the trust embedded in a will, those assets are not counted as an asset. That trust is not viewed as countable. So it's a way to get assets protected by putting a trust in your will for your spouse. Whatever you leave for your spouse should go through probate. And that's the opposite of what everybody's selling out there. And there were a lot of lawyers doing AB trusts, trusts for geared to minimize the mass estate tax.
Mm-hmm.
And that's also done as a trust that avoids probate. But if that same trust were embedded in the will, all the assets that can be used for your spouse on a discretionary basis would be protected from a nursing home. It's kind of amazing that it's been there for 40 years and that it's not that well known, but it's probably the most common estate plan that I do.
Right.
But it's a strange situation because you want to load up the spouse who dies first, and that's contrary to what a lot of people think. A lot of people think, get all the assets out of the name of the one who's going to die. We're actually
Right.
loading up the one who dies with the assets so that then they'll drop in trust, that they're there, they can be used for the survivor, but they don't belong to the survivor for MassHealth purposes.
Okay.
So that's the big difference between the two practices. And this overemphasis on probate avoidance is what causes people to not look at this. I think selling trusts is a big thing out there.
So MassHealth and Medicare are often confused. Can you give us a 2-minute version explaining the differences that every lawyer should know?
Well, I'll give you a 30-second version.
All right.
The Medicare is what you get when you retire. It comes as part of your Social Security. It's funded through your Social Security benefit. And it covers, it's essentially health insurance. Medicaid, or MassHealth as we call it, is like the health insurance provider of last resort. It's something that you have to qualify for based on your
Right.
assets and your income.
Advance your practice with the MCLE Online Pass. For one monthly subscription fee, you can access everything MCLE has online: live and on-demand webcasts, ebooks, forms, checklists, and more. Start your free trial today at mcle.org/onlinepass.
So what are some of the common pitfalls attorneys fall into when advising clients about asset transfers and gifting? And I know we talked about putting the trust into the will, but
That's a big one.
yeah.
If you put your assets into an irrevocable trust, the trust has to say principal cannot be distributed to you. All right, so income can, and the income would remain available on a nursing home stay, but the principal has to be prohibited within the trust. What if you need it later on? I mean, so if tying up your assets means they're not there for you anymore, that's a problem. I mean, you're essentially giving them away. Is that a good thing? It's not a good thing for everybody.
Right.
I mean, part of my practice is terminating these kinds of trusts. I just had one that came in a couple of days ago, where we had to go into the probate court and ask that the trust be terminated because the person had transferred assets in on the assumption that he was protecting his assets from a nursing home, but now he needed assisted living and he couldn't pay for it. All right. So
Yeah,
there's the balance. There's a balance here of protecting your assets and protecting yourself. So if you do too much Medicaid planning, it's not helpful to some people.
right. So how does this balance though? The commonplace understanding is that, folks are concerned that they're going to lose their home if they go into a nursing facility. So, what's the truth, and how do you balance, you know, protecting assets from that, or and having them available to you?
If all you have is in your house, if that's
Right.
if that's your retirement fund in effect,
Yeah.
then you really shouldn't be tying up the house. If um, now my numbers are off because of real estate going up, but this is the numbers.
Okay.
These are the numbers in my head. Like if somebody had a $600,000 house and no money, I wouldn't do that. But if they had a $400,000 house and 200,000 in money, banks,
Hmm.
CDs, IRAs, um, I'd be more inclined to do something about the house because I know they've got money,
Right.
you know, and it's a matter of, you know, some people come in here. I want to put my house in a trust. I want to protect. I want to protect myself, is what they're saying. That's not
Right.
protecting yourself. That's protecting an inheritance for someone else,
Right.
which is just the opposite of protecting yourself. So what do? It's a balance. It's really I don't think it's one size fits all. Um, there was a case out of New Hampshire about 10 years ago,
Hmm.
maybe Brademan was, and the trust had a side door. Now this is what I used to do a long time ago. The assets could be moved from the trust out to a beneficiary who could then conveniently use it for the parent who set up the trust.
Okay.
All right. It's the side door. Well, Brademan saw that side door in use and disqualified the trust. And MassHealth lawyers know about that case.
Right.
And I think they look at that. So while in the up to about 10 years ago or more, you might be able to get away with the side door. I don't think you can really use that effectively at this point. I know that
Right.
there is at least one lawyer out there doing MCLE programs talking about this. I just don't agree.
Right.
That it seems dangerous to have a side door in an irrevocable trust,
Right.
a
Okay.
discretionary side door. But that's what someone could possibly do. Uh, Now, there might be somebody who's willing to take the chance. I don't have enough money to get through, but I want to protect my house. I realize that the side door may not work. And, if a client is presented with the option, maybe the client goes with it.
Right. Take the chance, and if it doesn't work out, then it doesn't work out. But
Right.
right. Okay. So, what are some of the ways to help a community spouse stay financially secure when their partner needs long-term care? And I
All
guess,
right. So this is almost the easy one. You
okay.
move all the assets to the community spouse.
Right.
It's
Right.
it's an exempt transfer. How do you do it? Well, you make sure that while you're still competent, that you sign powers of attorney that allow transfers between spouses. There are a lot of powers of attorney, a lot of forms that put limits on gifting.
Hmm.
You need a power of attorney that is explicit that you could move anything over. All right. So
Okay.
any amount can be moved over. Now there's a cap on what the spouse at home can keep.
Okay.
But they could buy an immediate annuity and with the excess assets for their own benefit. So um, the cap right now is like about 158,000. So the
Okay.
way to look at it is the first 158 belongs to the spouse at home, the community spouse, and everything above that effectively is owned by the spouse in the nursing home.
Sure.
But the community spouse can use those excess assets and buy an annuity and keep them and keep the check.
Right.
Um, we had litigation that we lost and Supreme Court didn't want to take on the case, denied cert, where Massachusetts is requiring that the state, be the beneficiary if there are checks that are still due on the annuity when the community spouse dies. So the community spouse buys an annuity, can keep all the money, can receive all the checks, but if you die before the term is up, the state is the beneficiary to reimburse the state for what they're paying for the institutionalized spouse.
Right.
So what that means is you don't go with a long annuity, you go with the shortest you can find.
Right. Okay.
There are institutions throughout the country who do this sort of work, and you can buy a 2-year annuity in some places.
Mm-hmm.
The idea is to get the money back fast.
Okay.
Now it gets now here's the difficult part
Right.
of this kind of planning. So let's assume the husband is the one going to the nursing home
Okay.
and the wife is at home. He might have a big IRA, or he might have a 401k. He might have
Right.
pre-tax, a large pre-tax account. You
Mm-hmm.
can't transfer that over to the community spouse. You got to take it out and get taxed.
Okay.
So you don't wait till the last minute to start knocking it down. I've got a lot of clients who have over $1 million. And they're just taking out the minimum every year.
Right.
Right. So one of my planning options for these kind of people is don't take out the minimum. Try to get all the way up to the 32% federal income tax bracket. Start knocking it down without hitting the 32% bracket. And
Right.
it's because you can move the money from spouse to spouse without tax if it's outside of an IRA.
Okay. How are the recent and upcoming changes at the federal level shifting how practitioners approach mass health eligibility planning?
Well, we'd have to know what they are.
Right.
So I don't know what they are yet. Who knows? Maybe this idea of a testamentary trust, the trust that's embedded in your will, is in there
Yeah.
and it's been taken away. The annuity that I suggested before, there was a proposal about 8 years ago to make any annuity bought by a spouse treated as the income or the check from any one of those annuities, half and half between
Right.
spouses. Who knows what's in there?
Right. How should attorneys outside of elder law, folks like personal injury or real estate lawyers, when should they spot when it's time to bring in a specialist, an elder law specialist?
Wow,
Yeah.
that's a tough one. That's whatever I say is self-serving, isn't it? Well, it's really not just about assets, right? It's about
Okay.
the client understanding. Here's the way it works. Here's the big picture of how it works. It's if you tie up your assets, they're not yours anymore.
Right.
So I mean, this is not an area to dabble in. I'll just give you one example.
Yeah.
If you've got 3,000 in the bank and you're applying for MassHealth, and I've got a business worth 2 million, I get to keep the business if it's earning income.
Right.
You gotta spend down from 3,000 to 2,000. I mean, it's patchwork. It's all, like rules that you wouldn't believe. So when do you bring somebody in? I don't do real estate transactions.
Right.
I handle sales for decedents, or people.
Hmm.
I don't, I never handle a purchase. Um, I don't do PI cases. There's so much there that I don't know.
Right.
And so I, I think that this testamentary trust idea for a spouse is a big one. And if they're just doing a standard will for married people, that's a problem. So I would say that the first client group to look at is a married couple because they have options. There are things that they could do. The other one would be a family with a disabled child because a
Right.
transfer of assets to a disabled child or a special needs trust for a disabled child is an exempt transfer. You could put it all in trust for the disabled child as you're applying for MassHealth, and it's permitted.
Okay.
So those are two big groups that they should refer out, I think.
Sure. Okay. I guess finally, we know that you are the chief editor of an MCLE book that covers all of this and more. It's called Elder and Disability Law in Massachusetts. Is there a particular chapter or section that you think every Massachusetts lawyer should be reading, even if elder
Well,
law isn't their focus?
well, the book is over 900 pages, so it's, I
Right.
um I actually happen to have the book. We put sections together.
Yeah.
Um, Now there's a lot in here, and there are 44 chapters. This part 5 deals a lot with the asset transfers and all the kinds of things we've been talking about here.
Hmm.
So that's chapters 32 to 44. But you got to know some of the other things too, because we haven't cross-referenced every little nuance.
Right. When it comes down to it, the key is knowing enough to know when you're in over your head and you need to find expert help, I think.
Well, that's true in everything,
Yeah.
The first couple of times you do something, you're just sort of getting a feel for it. The first couple of times I handled Superior Court cases against the Mass Health Agency, it just felt like a new world. It with Rule 9A, um, you get used to it after a while, but the first couple of times you're missing things, it
Right.
seems.
Brian, I want to thank you so much for joining us here today.
Okay.
And for folks who are interested in a little bit more, you'll find a link in the show notes to the book we were referencing, Elder and Disability Law in Massachusetts. I encourage
And,
everybody to check it out. So
and we're going to be starting the process of editing the book and producing a second edition later this year.
I,
It's
I get the feeling that you're going to be producing a new edition and editing almost as soon as each one comes out. So
well,
with the constant changes we're seeing, I wouldn't be surprised.
well, as soon as we got the book done, the mass estate tax law changed. It's like this is so. I mean, there's never a time. There's never a good time to start the editing process.
Right.
Unfortunately, libraries have physical copies of the book. All right, so we
Yeah.
can't. We have to do the book around on the editing system
Sure.
around that. Otherwise,
Yeah.
if it were just digital, we could just do one chapter at a time whenever we
Yeah.
needed it.
And just slap the edits in. So,
Yeah.
but anyways,
All right.
Brian, thank you so much. Really
Okay.
appreciate it.
Thank you.
We'll hope to talk with you soon. All
Take
right.
care. Bye.
Thanks. Bye.
The MCLE This Week podcast is a production of Massachusetts Continuing Legal Education in Boston, Massachusetts. For sponsorship opportunities, email us at podcast@mcle.org.